Yep, so the WildTech DC Senior iPad program, its owners and presenters offer technical assistance, virtual help, well-being information designed for educational purposes only. You should not rely on the information in any applications or topics made by WildTech, including but not limited to mobile device applications and any social media pages maintained by WildTech, its owners or presenters as a substitute for professional medical advice, diagnosis, treatment, or legal advice. Thank you so much for letting me read the disclaimer. And again, thank you all so much for coming on to today's Tuesday 1:30 p.m. session. And I would love if you all could just give an introduction of what you be all doing today. And other than that, thank you all so much for coming on, and the floor is yours.
All right. Thank you, Alex. I'm happy to have Rashi back today with us. But first of all, I want to talk about these backgrounds. I see all these flowers, Miss Doris, Miss Carolyn, and all these beautiful festive spring backgrounds. Black History Month backgrounds. I don't know if you all had a challenge going on or what, but you are definitely bringing some sunshine into this cold Tuesday weather. So thank you all for allowing us to come back. We are Innovative Touch. We've been looking forward to coming each month and speaking with you all about real estate. I wanted to start, like I always start, just talking about our company. If people were not here last month or the prior month, we're a real estate brokerage, and we serve clients in Maryland, DC, and Virginia. A big component of who we are is community and agent client advocacy. So we work with a wide range of clients with helping them find homes, renting and purchase, and also listing their homes. We have clients in the military to relocate. We work a lot with first responders and teachers, and then those who are looking to relocate and move to multi-generational housing, 55 and older communities. So just a vast array of housing options. So I am the broker of Innovative Touch, and Rashi is one of our esteemed agents. And Rashi, you see, oh, I see you. All right, Rashi. We are both here to answer any specific or personal questions that you may have outside of today's session as well. Now, I will say there are a few members here who we have been trying to follow up with. So definitely when you contact us, let us know your best method of contact, whether it be the phone or text message or email. We want to make sure that we're doing our due diligence to get back to you. Having said that, there were a few questions that were posed in the last session that we always kind of want to start with answering any outstanding questions. One of them, and this is my fault because I could not find the contact information of who asked this question. So I wanted to make sure that it was answered. And the gentleman who asked it, if you would still like to follow up, please contact Rashi and I. And it was about like if there's a damage to your property, if there's a flood, if there's a fire, then who's responsible for what? And so in those events, if you are a tenant, your landlord should have homeowners insurance for the property. But in most cases, the tenant is responsible for renter's insurance to cover your personal belongings. So that to cover any clothing, anything that's not attached to the property, like the appliances or things that would be the responsibility of the landlord, your personal items. The renter's insurance will most cases cover any of those damages. Another question was about moving forward with purchasing a home or relocating. What were the next steps? We always suggest just doing a consultation so that we can really understand what, oh, I'm sorry, my apologies. I'm just looking at this. I see that it's cut off. So that we can discuss your needs, whatever concerns you have, and to get you in the best home. Um, so we are available for that as well. Okay, the last time we talked about like the different steps to prepare for moves, the different resources that are available within Washington, D.C. to help with packing, to help with cleaning and even repairs. And there were some great members who chimed in about the bulk trash schedule, all of those things. I think Alex has it recorded from the last session. But again, for some of the more specific answers that we aren't able to provide, we did provide some additional contact information. And also to piggyback off of that, we have this week's speakers. So our very first session, there was a question about reverse mortgage and then a question about living wills. And we always want to refer somebody who we've done business with before because we already kind of have a rapport and know how they operate. And I am happy that Julius was able to join us today because it was very last minute on our part. We've been reaching out to him for the end of the year, and then it was like, oh snap, this is next week. And we were able to connect initially, and he was able to free up some time in his schedule to talk about some of the things that were brought to us in the first session. And so Julius, or Mr. Terrell, worked with my sister and I actually with my parents' estate. Both of my parents ended up passing away a few years ago, and we needed to get the estate in order. And so not only are we talking about on the probate side after someone has passed away, but he also works with living wills. And so it just really gives a sense of peace and knowing that a professional, someone who you can trust, in a very reasonable, cost-effective way, can handle and walk you through that process of what that looks like in regards to your real estate, as you transition to a new house, or just making plans for the future. So he's here today to join us and share a little bit of what he does, to include estate planning, probate administration, business and family litigation. And then he also does government relations. He handles that as well. So he would be the more appropriate person to answer some of the questions that were posed to us in regards to the legal side of real estate. So we are happy that he is joining us, and I am going to stop sharing my screen so that Julius, you can share what you would like to share about real estate.
Thank you. Thank you, Kristen. I appreciate the introduction. I appreciate presenting to the group today. Again, I'm Julius Terrell. I practice law in both Washington, D.C. and in Prince George's County. And I go to other counties in Maryland as well, but I have an office in Largo and one in D.C. We have a small staff, another attorney, and several other staff persons here to assist families when needed. As Kristen said, we primarily do estate planning and probate service work. Estate planning, as you may or may not know, is where one individual or family plans the disposition of their property, the transfer of their property at a point in time when the individual is no longer here. So in that instance, probate allows individuals to use either the state law to transfer properties or private decisions that you make. And again, if you have no estate plan, if you have no will, there is a law that's called the law of intestacy. In and before I go there, I don't have any um, uh, display material. This is more of a conversation today. I think it's usually best just to have a conversation because there'll be questions that come up, but usually when I do the illustrations, it takes away from the conversation. Um, so in that vein, the law of intestacy is in Maryland and DC and in all 50 states around the country. Each state has their own law in the event that a person passes away without will. And in general, the law of intestacy says that individuals' property shall flow equally in equal portions to their next living heir. And living heir in Maryland and DC is defined as a lineal descendant. A lineal descendant is up or down. So up would be parents, grandparents, down would be children, grandchildren. In the event that that line, if there's no one in that line to succeed or to serve as an heir, then it branches out to siblings, aunt, uncles, and cousins generally. And once you get to one group, that group would split the inheritance in equal portions. So just kind of giving a little tease there. If there's no will, the law of intestacy determines how an individual's property shall be shared or be given or be distributed upon passing. But before we even get to a will and planning for when we pass away, we have to plan for while we're living. And the most important thing while we are living is to have powers of attorney to be established, to have an individual that we choose to serve as our legal decision maker when we are unable to make decisions. So in this instance, you would be able to establish a power of attorney for healthcare decisions and financial decisions. For healthcare decisions, anytime you go to the doctor and you need general procedures to be performed or you need medication, in the event that you're incapacitated, and that's without the ability to understand what is impacting your care at that time, if a doctor determines that you're incapacitated, they can refuse to accept your instructions for whatever the care is. If it's to have a basic procedure, if it's to order your medication, if it's to continue with therapy, all of those require a certain level of legal competency. Competency is determined whether or not you, the individual, are able to understand what the doctor is conveying. And anytime there is a lapse in that, if they determine you to be incapacitated, then they will look to see if you've made a decision of appointing someone to serve as your power of attorney. And essentially, a power of attorney could be anyone 18 years or over.
Oh, they give you all of these different options.
18 years or over who are able to effectively receive information and could effectively make a decision on your behalf. And that decision is legal informed consent. Informed consent is when someone stands in your shoes and makes a decision on your behalf. So these are I mean, most of the times, if we don't have powers of attorney, a lot of the hospitals have standard documents, and when you come in for physicals now, they're asking if you have whether or not you're incapacitated or not. It's just a lot of the hospitals now, particularly since the pandemic, they're helping the public make their records most efficient for what they need. And what they need is the abilities to provide healthcare services. And again, if a person's incapacitated and can't understand, and they don't have powers of attorney in their medical records, then they will look for um, the next legal way to obtain the instructions to help an individual. So the levels of instruction is a person has competency. They are not incapacitated. They can give instructions. That's what happens on a daily basis, no problem. Second level, you go in, the physician determines that you're unable to understand the severity of the situation because of um, some form of incapacity. It could be dementia, it could be a physical incapacity. You could be in a coma, for instance, and without the abilities to even communicate. Once they determine the person's incapacitated, then on that second level, they then look for a substitute decision maker. And oftentimes, if you have provided your doctor with your powers of attorney, the information will be in your medical records. But and now, if you don't have them, when you check in to most of your appointments, most thorough offices will ask if you have powers of attorney, or they will also ask if you have an advance directive. An advance directive is a third level of decision making that we can provide to another. And an advance directive, which is also called a living will. So, a living will and advance directives are synonymous, they're the same. And what those documents do, different than a basic healthcare power of attorney, is they ask for the authority for life ending decisions. So, life ending decisions, anytime you're in need of the use of artificial means to maintain life, there's a determination that there is a third level of permission if the individual has not instructed the medical team of their view. So again, you come into the hospital, you're having a procedure, they'll most likely ask, for your permission for anesthesia and permission to participate in a procedure. No problems, you give it. Well, if you are under anesthesia and there's some complication, if there's a need for um, life support, intubation, or hydration. It also could be for pain management, the use of morphine, for instance. Then you would need the advance directive or living will, and that allows a third party, your power of attorney, your agent, to provide instructions to the doctor on whether or not the artificial means is to be used. And when you create that advance directive or living will, it's important that whoever you empower with that decision, it's important that they know how you feel about the use of artificial means and the use of morphine for pain management, for example. And if so, for how long can these things be used? Is it a matter of days? Is it a matter of weeks, or months, for instance? So all of those decisions for life ending uses on the third level, you need an advance directive or a living will to allow someone other than yourself to instruct and to provide legal consent or informed consent to use or to participate in using the equipment that might be of need. So I see one hand coming up. Let's see, Miss Ann Dennis here. Let's see.
Good afternoon.
Good afternoon.
I've heard great things about you in PG County, so
Oh, thank you.
I wanted to ask you a question.
Mhm.
If you have a power of attorney, medical power of attorney, and you have a will, do you need an advance directive? Or should you have one?
Well, both of yes. Thank you for your question. Thank you for the compliment. You can keep those compliments coming. I appreciate
Okay. I just happen to know somebody that has dealt with you, and they gave you great praise. So
appreciate that. So the question is, if you have a medical power of attorney and a will, do you need an advance directive? And for the most part, yes, you will need it, because when you say medical directive or power of attorney, most of the times they are broken off to separate. Most of the times they're broken off into separate documents. And in those separate documents, each document is conveying a certain amount of authority. It is possible now, and let's just say the will is not important in this scenario, because when we're living, the living documents speak to what authorities we're providing, and those living documents are the advanced directive, power of attorney for healthcare, and power of attorney for financial decisions. And then there's one other document, which is the HIPAA document. And federal law just says if you want a third party to access your medical records, you have to give a certain release for that. But for the most part, most of the planners that I see, because of the importance of the advance directive and the significance that they play, they will break those off so that it's clear that in one instance, the general authority to make decisions is given in the basic health power of attorney, and then separately for life ending, there's a separate authority being given. And usually, and how we do it, we break those off. However, there is in Maryland, there is a uniform document that you could use, optional, that the state provides. So, for instance, and in that document, the power authority is given in one document, and it's provided in that way. So yes, to answer your question, it depends. Most of the times they're separate, but it is possible to have one document that provides for both the basic level and then the life ending, or the use of artificial means, in that authority in that instance.
Okay. Thank you. I
Mhm.
appreciate that information.
You're welcome.
I have um I have a living will. I have a regular will. I have covered all my bases because I don't want to come back and kick my son's butt.
That's good. That's good. Well, you sound
But
definitely
I
prepared.
was concerned about the I'm sorry, my mind went blank. What you
Mhm.
call it? The last
The-
thing we
yeah, the advance directive.
but yeah, thank you.
Mhm. Yes. Okay. No worries. I have
I, I,
another
I
question.
I
Okay.
appreciate that very
You're
much.
welcome, Miss Dennis.
Okay. Hmm.
And,
Go to
sorry, Ms. Diane. Hey, Diane, how are you?
I'm not Diane, I'm
Oh,
Doris.
yes, yes, I know. I actually hit,
Hello,
thank you, of course. Hi, Diane, how are you today?
just fine, thank you. How are you?
Good.
Uh,
okay. Go. Doris.
sir, sir, I'm
Who?
confused right now.
No, Diane, go ahead, Diane. Go ahead, Diane.
Please repeat your name, sir.
Julius Terrell.
Mr. Terrell, I don't have a will.
Mhm.
So what I wanted to know is what I have to do to get one, what I have to do, how will I find out? I have one son, but he has sisters and brothers. And if he precedes me in death, or not precedes me, die after I do, and I don't want it to go to them because I don't know them, what do I have to do?
Well, thank you for your question, and just for my clarification, is that Diane asking the question?
Yeah,
Yes,
yeah.
yes,
Okay, all right. Thank you, Miss Leach. So you have a, a son, and your son has half siblings from his father's side,
right.
and you want to know if you leave him, if you make a gift to him, and but then you also said if he dies before you or he dies
No,
after,
no, no, not before me. If he,
if he dies
after
after
I,
you. Okay,
right,
well,
and
perfect.
he don't have a will,
Yes.
but
So if he,
I
if
have never acknowledged his brothers and sisters.
okay, so you can control that by just creating your own will and saying that you provide your property to your son, and in the event that he passes away with no children, if that's where you want to draw the line, then the property shall be redirected elsewhere. Now, if he has children, I imagine you want your heirs to receive it, but you don't want his half siblings to receive it. And it could be an issue where it would pass through to the half siblings if um, uh, his estate, and just say, and this happens, um, a person passes away, and then shortly thereafter, they're they're survived by their child, and shortly thereafter, without a will, um, the child passes away. Now, in that instance, no, that plays out differently in Maryland and DC, just subtly, but there's a difference. Um, if there's no will, then the law of intestacy is going to control. If there is a will and it goes to, as soon as a person passes away, the right then attaches to the receiver. So now that person
You
has
missed me there. I don't know who to receive. What is the
the
receiver?
inherit the your son who's inheriting.
Oh, okay,
He's
okay,
receiving your property, but
right.
before he receives it, he hasn't created his own will, for instance. So now that then comes back to the general rule of the law of intestacy. And he has no children. Say if he has no children, then the law would say we go up or down and find the first nearest relative. We go down first, children, no children, then we go up, and the parents haven't survived. Then we would go siblings. Now we have someone on the sibling line, and so in that instance, the child receiving from their parent having no will, then their estate is divided between their siblings. Now, that's the result of him not having a will, but also it starts from that you could have controlled the gift in a different way. You could have cut off the right for his estate to do anything with the property if he wasn't survived by a biological child. So then what that rule is that when we call it a gift shall lapse, a gift shall end, a gift shall terminate if this doesn't happen. So we can create a solution for that, but the bigger point is that it's important that we all make decisions so that we don't have the state law to determine how our property is to be shared or to be divided upon passing. All right. Did you follow that?
I did. I got one other question.
Okay, go ahead.
Years ago, my sister passed, but she has uh, unclaimed property. And when me and my sister went to claim the property, they told us it wasn't worth claiming because it would cost too much. How does that? How you handle that?
Well,
First
there.
of all, we didn't know what the property was, and
Okay.
they didn't tell us.
So that's where you would start from. They should be well. If you have an inherit, well, let's even start. But so it's unclaimed property. So for unclaimed property, I just did one for a family in DC, and they ended up it was 6 different claims, and you have to file each claim, and it was like $32,000. That was a real coin after it was all said and done. Paid for my services, gave the family, something more than nothing. I mean, thousands of dollars. So if a person has unclaimed property, in order to determine, and in DC, this is what in order to determine what it is that's being held, the estate has to be open and a personal representative has to contact the unclaimed property office to start the process. So you have to start the process to eventually find out what's being held in the unclaimed property. It's a whole, they don't make it easy, but if you stay with it, you will eventually find out what it is. Now, that might cost you time. Now, you don't necessarily, even for that process, you don't need an attorney. You just need to fill out the application, be patient, find, whoever you talk, call the office, develop a rapport with, whoever's in the office so that you can get the information that you need. Because
But
my view on unclaimed property is just like anything else. They're wanting people not to be diligent so that money can, you know, pay for their bonus, pay for their Christmas money, pay for,
well, how long do you have before you can before it can literally go unclaimed?
uh, each, I believe DC is 7 years. I would have to give you the period of time. I think it's 7 years. Once a property is held for 7 years, it turns over, and the word is escheat, ESCHEAT. It escheats to the government. And this is a good exercise for all of you. I mean, if you live in Maryland, DC, look up unclaimed properties. and it'll have a name associated with it. So it may have Diane Leach. Now, if it's your name, like say if you have a common name, it's no problem with starting out. Hey, well, I'm Joe Schmo, and they have a Joe Schmo here. Then they'll get to a point where okay, we're looking for the Joe Schmo living at this address. Now, if you're not at that address, then that's something else. If it's an unknown address, hey, I'm Joe Schmo. I just didn't get my. Stay with it because there are instances. Well, one where you find that there is some money, and a lot of times it's little. Like, um, you have a bank account and you never close it, and they have
Right.
$10, and they just send that to the government. Sometimes, like if you have a real estate closing and you have an escrow and you never go back, or the title company, and that's a whole nother. The title company never sends you an escrow. Um, technically they're supposed to send that money to the state now, and may not ever go. But it's a good exercise to find out about that office, and then go online because a lot of this is online. Find your name, see if you got some money in there, and go get your money. And if you need help, um, it really takes if you've got a diligent, grandchild or a child who likes writing letters, who likes talking on the phone, and who at the end of the day, hey, we get some money. Some of it's going to be yours, whatever you got to do, or you may be able to do that yourself. But it's not a difficult process, and it's one that we should all do probably yearly just to see, because you never know.
Thank you so much.
You're welcome. I'm gonna go one more question, and I think that's gonna be Doris, right?
Yeah, and just really quick, just hearing that question and your answer, Mr. Julius. So basically, having a will is important. One reason is to put, whatever property that you might want your heirs to have in that will, so that way there's kind of none of that other things that have to go on, and it just makes it more seamless, correct?
Yes, and yeah, wills are important, and I can get into what a will is. I mean, a will is a way that we transfer the property that we acquired over a lifetime, and we transfer that to whom we want that property to go to. So that's the tangible side. But
Mm.
I usually start from, let's talk about the legacy side. How do we want to be remembered? And a will is a document that you also can convey your values, your morals, your traditions in that document, along with the transfer of property. And you're giving your blueprint, your guideline to your life, and you're transferring that guideline to your loved ones. Hey, this is how I suggest that you live your life, or you consider living your life, so that at the end of it, you can also bless someone with a gift. And with that gift comes your legacy. So it's a way that we convey property, but on a bigger and a more important way, I think we convey our legacy to our loved ones. And a will, okay, so let's just go. How do we create a will? There are different ways. You can go into an office and come to my office and come to anyone's office. They can prepare a will for you. Oftentimes, for me, for a single person, just for a will is $400, for instance. You could save money. You could do a will yourself, for instance. And sometimes I do will workshops where I go to certain places, and for whatever reason, be it lack of means, lack of whatever, individuals may not have the abilities to have someone to prepare a will. So we'll do a workshop and say, okay, well, let's create your own will. And in this workshop, you're going to state your name. You're going to state some particulars about yourself. and you're going to also identify your loved ones, and then you're going to identify property that you want to give to your loved ones, or you could give things to entities. You know, it could be a nonprofit, it could be a church, it could be a business, it could be a school. So there's no limitations on who you can transfer your property to, but it has to be done in a legally valid way. And so there needs to be what's called precatory language, which is just language that gives rise to the importance of the document itself. You know, I hereby, under my own free will, convey through this instrument to the individuals contained in the instrument the rights to receive property that I so describe in this document. So now, if a judge, okay, and so we have that precatory language, we have the descriptions of the property, we have the descriptions of the loved ones, we have our personal testament of who we are, and then in a workshop we have we need two witnesses, and those witnesses can't benefit from the will itself. So, so long as they're not a recipient of a gift of the will, then that person could be a valid witness. And so in a workshop, and we go through, and you know, people take time to write in their own handwriting, you know, the things that they want to give, to whom they want to give it to. We have the important precatory language, and then we have two witnesses that don't receive anything. Now we have a will. Now that will, you know, different names it's called, but that is a valid will. And you hear about deathbed wills. You know, persons that are on their deathbed, they create will. It's possible, so long as, you know, the precatory language is there, and so long as it's witnessed. And if you don't have two witnesses, you could have a witness and a notary, and the notary could serve as the notary to the creators, whoever created the will, their signature, and then they can also serve as one of the witnesses. So, so a will allows us to convey property that we've acquired during our lifetime, and it allows us to transfer or to make a distribution or to make an inheritance of that property to an individual or an entity. And that's a will. A will, in general, has to go through probate. A probate is the process that each state has for the winding down of a person's legal obligations after they've passed. And I say legal obligation. Legal obligation in this instance would be anytime we have property that we receive from another, it's usually a contract associated with it. If that contract has been satisfied and the property is wholly owned by you, then we own it outright. We don't have to answer to anyone. If there is still a debt owed on the property, then the creditor, whoever's owed the money, needs a way to claim what their interest is in the deceased person's estate. And so they can file a claim. And this is why probate is important, because it gives a way for us to wind down obligations that may not have been satisfied before passing. It's kind of unfortunate, but there, you know, on the first level, creditors have a way to be made whole. Now, there are ways that a creditor cannot, a creditor is not satisfied at the end of the day. So if we pass away and I'll just go just gently into this one because it looks at different types of property. But we have secured property and unsecured property. Secured property is anything that the agreement is protected by the property itself. So a mortgage is a secured property because you get a mortgage, and in the financing agreement says that the house is collateral, right? The house is collateral for the mortgage, so therefore that is secured. If you buy a car, the car is collateral for the financing agreement that you have for the automobile loan. You buy a refrigerator or any item, if the item itself in the agreement says that it stands for the collateral, then that's what it is. It becomes secured. And why that is important is because and as we know, it's like if we're living and we can't pay a secured debt, what happens? Foreclosure. They can come back and get the property. Similar, if we have not satisfied the debt after passing, the house or the property can be turned back over to the creditor. You follow me on that? So that's secured credit. So the other one is unsecured, and unsecured is like a credit card debt. It's where you're buying things, you're receiving monies to buy things, but there's no security against the item that you're buying. So when we pass away, secured debt, for the most part, can be significantly reduced, if not wiped out outright. Secured property has, at a certain level, it either has to be refinanced and kept, or it has to be sold and satisfied. Okay, so we have a reverse mortgage, for instance, and something. How many of you have reverse mortgages on your properties? Thumbs up, reverse mortgage. Okay, so there are a few reverse mortgages. So a reverse mortgage is secured. So before a family member can take possession of property that's subject to a reverse mortgage, the reverse mortgage has to be satisfied. And generally, in general rules, within 6 months after passing, the property has to be either sold, refinanced, or taken over by another family member so that the loan could be satisfied. So those are reverse mortgages. So the type of property that we have is going to determine whether or not a creditor can file a claim against the property. And the reason why we have probate process is to transfer ownership of property, but also to settle debts that that property may be subject to. One way that can avoid some of that is by using what's called a trust. And a trust is a will that is on steroids. And not only is it on steroids, but it's on steroids and it's driving a fast car. And why it is, a trust allows property that's titled inside the trust does not become subject to the probate process. So it's conceivable that you could have a piece of property that has that is security, that is as part of a secured financing agreement where that property inside the trust is collateral for something that's an agreement that's outside of the trust. And for a while, it might not be an issue. And this is where some people have a different understanding. So a trust won't, so you buy $1 million house and you have a $500,000 note at the time you're passing, and you have the property in trust. So we have 500,000 owed, we have property in a trust, and that trust is going to benefit family members, no problem. Well, those family members, as long as they're paying the note for that 500,000 remaining, there's no problem. But soon as they start making that payment, then the mortgage company, not only they're going to find out that the person has passed away, they're going to find out that the property is in a trust. And now they have their old agreement, and their old agreement says that, and most of the mortgage agreements says due on sale, due on transfer. And when it has that, then they can exercise the right to foreclose because the property agreement is not being satisfied. So for a while, if it's in trust and if they make the payments, no problem, no harm, no foul, even though the person who started it is no longer living, they just want their money. But if the money stops coming, then they're going to exercise their right to foreclose and take over the property until it gets satisfied. So a trust can insulate property, but it can't avoid obligation. Okay, you follow me there? All right, so we're gonna step back. I'm gonna let let's see, Doris has a question. Go
You
ahead,
done
Doris.
talk so long, I forgot what my question was.
Oh,
Because I don't know, you done went to all this stuff, and I'm being faithful with you. So my daughter lives with me, right? So when I took the loan out on my house, it was me and my sons. But I wanted to use the will to for my daughter to have the house.
you could
So
do
how would I do that?
well, a couple things you could do. So if your daughter is, if you want to add her to the deed before you pass
She
away,
can't be added to the deed because she gets Social Security.
so you're okay. So then you could use a trust and make her the beneficiary of the trust so that she then is entitled to the use of the property until whatever point in time. And so the property's not going to be in her name, it's still going to be in your trust name. So when she tries to qualify for her, annual recertification, whatever, or Medicaid, Medicare, Social Security, what have you, it's not going to come up, right? Because it's owned by the trust. So you have that option there. That's a way to use that.
So how would I go about doing that?
Well, okay. So a trust. So how we do trust, it's like a personal contract, and a personal because it's a personal contract because you own the property
Mm-hmm.
and you have created a trust that you own. And so you're mainly taking something that you own individually, and then you're placing it into a trust that is a separate entity holding things. And so it's separate from you, the individual. Now it's you, the trust holder. And then you're able to control it because you are the what's called the grantor or the creator. You've created the trust. So while you're living, you're controlling things that go in it and go out of it.
Mm-hmm.
For trust creations and like my office, very basic trust is like $1,500, and
Oh,
then it
Lord.
goes all the way up to um,
I ain't got that.
4,000. $4,000. Oh, I got you. I got you. So there are some legal aid groups that do some trust planning, and then and then from time to time, like once a month, like in my office, we do reduced fee arrangements where we help those who need some assistance and the like. But we do a minimal amount of those, but we do try to identify those who need help, and some of our either our clients or some persons that we do work with say, hey, we have somebody that really needs help. And I would also suggest, if you're in that category, you contact my office and contact other offices do, and it's pro bono is one of the obligations that we have in the practice. So, it is possible to get that
What
work.
is your phone number?
240
Mm,
487
uh,
5961.
5961. And you Julius? Are you Julius?
Yes, I'm Julius Terrell.
Okay.
So trust. So we've talked about planning for while we're living.
Right.
That's the powers of attorney. We need that while we're living in case we, are ever incapacitated, and we can appoint someone to make decisions for us who knows what our wishes are, who understands.
Right.
It's very important that once we create it, that we talk to the person and let them know, hey, I'm okay with this, but I'm not okay with that, whatever that is and whatever this is. And I say that because again, the biggest thing is life ending. Do we want to use artificial means or not? Yes or no, and if yes, under what conditions? Oh, okay, if it's a probability of me returning, then yes. But if it's a possibility, maybe no.
I don't want that.
Just go right into that.
Yeah, I don't want none of that.
Gotcha. So, so while we're living, we have the power of attorney. Then, upon passing, now we have two different concepts we've talked about. The will. The will allows us to transfer property to individuals who are or entities who we want to receive our property. It allows us to create a legacy, sharing our beliefs, our values with our loved ones through our documents. And then we also have, in the event that we want to avoid um, uh, certain aspects of probate, we can use a trust, and a trust will allow um, the holding of property and to protect it so long as the obligations that are satisfied that meet the underlying agreement. So we talked about why we need these. Talked about some of the costs, privacy minors. One thing, if we're planning for, I often get a little issue with, a parent who says that they've done so much for their their children that they want to skip over them and they want to give whatever to the grandchildren. And that's an issue that we weigh
Well,
out.
I ain't got to worry about no grandkids. I ain't got to worry about that.
Oh, I understand. We had others, maybe not you, but we have others that could be an issue. And a trust is a real good tool when we want to allow the use of property or want to give property that may not be able to be given because a person may be, under the age of 18.
No, she 52.
Okay, well,
Mr. Julius, are you addressing Ms. Doris directly, or are you?
oh no, I'm back. Oh, no,
Okay.
not yeah, no, I'm to everyone. I was just giving an illustration of a different.
Yeah, We have a couple minutes left, so I do see we still have some hands up. I also do see that we have some things in the chat, so,
See how he cutting me off?
Hmm. Okay, well, thank you, Miss
I
Gudger.
got your phone number. I'll call you.
All right, sounds good. I look forward to talking.
yeah.
Let's see, Denise Jackson.
Yep, yeah, if you could also put your number in the chat for us as well, Mr. Julius, that would, we would really appreciate that as well.
Okay, got that. Will do.
Yep, so we have just a few minutes left. So, hi, Miss Denise, how are you?
Hi, how are you? Yeah, I'm not gonna be too long, but I want to ask a quick question. My father's deceased and he was married, and I wanted to ask you, he had a will, but excuse me, when he passed, well, he was real sick. So his wife had told me that he wanted to be cremated, and I never heard him say that, but anyway, she said she was going to be too. So when he passed, it's a will. So I was, while he was sick, I was saying, well, what's in the will? And she said, well, we're not going to discuss that right now. So I said, okay, well, so when he passed, she never read that will to me, but she got rid of everything, his cars, his personal things. I never got anything. Only thing I got was his ashes. And, I wanted to know, can that will still be read to me without her? Or it have
Well,
to be read from her consent?
no, no. In fact, the will should have been turned
Mm-hmm.
over to, was this DC or Maryland?
Maryland.
Yeah, it should have been turned over to the court because if the will hasn't been turned over, then there's no legal authority to effectuate the will because when you open up a probate estate, it gives the defined person who's responsible for administering the will,
Mm-hmm.
called the
Right.
executive, the personal representative.
Mm-hmm.
Once it's presented to the state confirms it, then they give that person what's called letters of administration.
Mm-hmm.
They can't act without letters of administration. So therefore, anything that may have been done, if it was only in your father's name and it was without the letters of administration, it could be reversed. If
I think it was in both of them names, but
well, that's
I'm
different.
not
That's
I'm not sure of it, but the way she talks, but I don't really deal with her, but the way things happen, and she hesitated because even the money that my father gave me, he told me that was for me, and I end up spending it because she told me he didn't have any money and whatever. And I end up spending it for his funeral and everything. And, I didn't mind because, I mean, he my dad. I mean, keep arguments down. I ain't going through all that. But I just didn't understand why that will still wasn't shared with me.
yeah, no, that should have been that should have happened very early on.
Because I
Definitely.
don't know what's in that will.
Right. Yeah,
And
it
this
should.
been now about, he been dead now, I say about good, about 9 years or something.
Yeah.
So, I just kept it on the down low, but when I heard you just talking about the wheels, I was just wondering, can I open, like without
Yeah.
her,
So
or do I need her?
right. So on that point, what could you have done if that was the issue? Someone
Right.
says they have a will. There are priority. The law says individuals have a priority to serve. And
Mm-hmm.
again, it usually, if you're married, spouse,
Right. They
children,
had
lineal
the consent.
descendants.
Yeah,
And
and they
so
have
if
all the
that,
control.
yeah, but if the will, so if the wife, because in this instance, you also had a basis to file to open the estate because she wasn't your mother. Right? And
Right.
so
No, she wasn't.
she
And
had an
I'm his
obligation
only
to turn
daughter.
over the will. To answer your question, she had an obligation to turn over the will. And if she
Mm-hmm.
didn't, then if you had filed to open the estate, then it would have forced her to present it. Or if she didn't, then everything would have been split 50-50 that was only in his name.
Mm-hmm. Oh, so, because
That's
I'm
the
his
difference.
only child that he had.
Right.
So,
Mhm.
so I still can look into it because it's still
Well,
puzzling
you know,
to
I mean, you
today.
could, but it sounds, 9 years is it's a long time,
Yeah,
definitely you want to make that move to open the estate as soon as close in time to when the person has passed away.
right. I'm not really concerned about what's in there he left me. I'm not concerned, but I just wanted to know what was in there because she also told me he wanted to be cremated, but I never heard him say that. But he might have did to her, I don't know. See,
Okay.
that's what I'm just saying. I would just
Well,
like to, it be read to me what was in there.
understood. Yeah. No, yeah. Filing to open the estate may have given you that option. So, but
Yeah,
it's
because I
something to
have
still look into. It's still
right,
something to
because I
look
have,
into.
right, because he have two grandchildren, which is my children. He might have left them something. I don't
Mhm.
know.
Yeah, you never
And
know.
she hiding it and she covering it all up.
Hey, Denise, we only have a couple minutes, so we would really
So
appreciate
thank you for your question,
you.
Lisa. I'll go to Elizabeth Braxton.
Oh, sorry, I have to unmute them, Mr. Julius. We only have a few minutes left, so if we can answer general questions, but anything specific, we have Mr. Julius's number and a website in the chat. So just a general question, we only have a few minutes left. We want to make sure to get to everyone. Mr. Harold, you had a question?
Quickly, Alex, I just wanted to greet my good friend Julius Terrell. I've known him nearly 30 years or thereabouts. And I want the people on this Zoom call to know that he's a very thorough, diligent, compassionate, professional, and a good brother. So feel free to reach out to him on that line he gave you. That's all I want to say, Alex. Thank
You
you
do
very
the
much.
same,
Good to see you, brother.
Harold. Good hearing from you, man. Good hearing. It's been too long.
Good. Man.
Thank you, Mr. Harold. Appreciate that. Miss Elizabeth, you have a general question for Mr. Julius? Miss Elizabeth, you there? You got to hit unmute in the middle, please. Okay, Ms. Duckett, did you have a question for Mr. Julius?
If one,
Okay.
how long is that will good for?
Okay, yes,
If-
Miss Elizabeth, and then we'll have Miss Duckett. Hi, Miss Elizabeth, how are you?
Hi there, Alex. If you have filed a will in probate, let's say around 2013 or 2016, in any year, say within a span of 10 years, for another issue, okay, how long can you use that same will to file in probate again for a similar situation that occurred before? Or do
Okay,
you have to
so
come up with another will?
no, a will is good. So I'm assuming the will was turned over to the court when you said,
Yes.
yeah. So once a court receives and enrolls the will, it's a document that, and so long as it's valid, it can go on into an existence into perpetuity until the requirements set forth in the will have been satisfied. So if the will hasn't been satisfied, and in this instance, just say that there was property that hasn't been transferred from the estate to someone else, there's a reason that the estate needs to stay open. And so long as you inform the court of the reason why the estate needs to stay open, the will and the estate and the personal representative will still have the authority to move forward. Now, in the instance that an estate closes, it could always be reopened if later down the road it was found out that there was, property that wasn't distributed, or that estate was going to receive something. That's a possibility as well. So, we talked about earlier unclaimed property. Just say if it was $100,000 that was found out to be held in one of the state's coffers. Well, and you had the estate open and then it was closed. Now that's the reason to open the estate. We need the estate open so we can go get the $100,000. And in the will says that all the remainder of my money shall be divided between my children equally. Now, open up the estate, collect the unclaimed money, and then distribute it consistent with the will. So,
Okay, I have other questions, but I can't do it right now. But you
okay, well,
practice
just
here in the District of Columbia.
I do. I have an office
Okay.
in DC, one in Maryland, Prince George's as well. I do
Mhm.
home visits if that's needed, and the like. So I definitely appreciate having the time and opportunity to share what I do and how I help families out on a day-to-day basis. And I do look forward to an opportunity to speak with you and maybe your loved ones going forward. And if at any point in time you have a question, don't hesitate to contact my office. I'll also put the DC number in there as well.
Thank you, Mr. Julius. We have one more question from Ms. Duckett, okay?
Okay.
Yeah, but all his website and Maryland number is in the chat, and Mr. Julius is putting the DC number as well. So make sure y'all check it out. Hi, Ms. Duckett, how are you?
Fine, and you all, I enjoyed the presentation. I just wanted to ask a question, but I don't know if it's going to be short or what. If all of the people that you have chosen to in the will are not here, is there something to be done about that? That's all I need to ask.
Okay, and I'm assuming not here, either not alive or not
Yes,
geographically in this
not
area.
alive.
Okay, yeah. So if they're not alive, depending on the language in the will, it's going to determine whether or not we talked about this concept of lapse. If a gift lapses, that means it ends after that person. It can't happen. If the gift lapses, then so long as there's another alternative recipient, then it would go to that person. But if in fact it described that the persons in the will, if they've all passed away, and there were no directions onto what happens in that instance, then the law says that then you go back into the statutory law, the testacy law, to see where the next closest family member is, and it's usually to the fifth degree. The fifth degree. So like um your second cousins, your great your second cousins, second cousin. So you got cousins, you got your first cousin, your aunt and uncle's the third, your first cousin's in the fourth. By the time you get to the first cousin once removed, or the second cousin once removed, then it's possible in certain states that property would escheat or would transfer to the government. And in Maryland, in DC, it transfers to the court. In Maryland, it transfers to the Department of Education. In the instance where you can't identify, there's no known heir to receive, and the law doesn't have a mechanism to transfer to any other person, then it reverts to the state. So we don't
All
want
right,
that to
thank
happen.
you so much.
You're welcome.
Thank you.
You're welcome.
Thank you so much, Ms. Duckett. And thank you, Mr. Julius and the ITR team for coming on to today's session. Do you, Kristen or Rashi, have any last remarks about anything that went over today, any takeaways before we end? But again, thank you so much for coming on to today's session.
Yes, thank you, Alex, and thank you, Julius, very much. I just also wanted to just briefly kind of say with real estate and with wills, one of the good things about having a will with an attorney is also telling your heirs where the will is, because that also is something that we have an issue, people have a will and no one knows where it is. And when you have it with an attorney, you can tell your beneficiaries who's holding the will and where it is to make sure that it's in safekeeping. And then also with just a note about elder care and when signing documents for real estate as well. Even if you physically can't sign, but if you mentally have the capacity to articulate the will, then sometimes it is also good to have the power of attorney just to have somebody physically sign for you as well. And that's it. I do see Mr. Angelo on here. I was waiting for a call back from you. So, but I know right afterwards I will be picking up my children. But definitely, if anybody has anything that is outstanding, any questions for Rashi and I, Mr. Terrell, all of our information is available. Thank you, as always, Alex.